If your company in Vietnam is receiving funds from overseas, whether through loans, shareholder advances, or partner financing, you're entering more than just a business transaction. You're operating within a regulated legal framework that governs how foreign borrowing works in Vietnam. Understanding this framework isn't just about compliance. It's about structuring your financing in a way that supports growth, without creating hidden legal risks. In this video, we'll explain what Vietnam's legal framework for foreign borrowing looks like, why it matters, and how your business can align its financing strategies with local rules and practices. When we talk about the legal framework for foreign borrowing, we're referring to the full set of laws, regulations, and procedures that apply when a Vietnam-based company borrows money from overseas. This framework determines how foreign loans are defined under Vietnamese law, which authorities regulate them, what documentation and approvals may be required, and how foreign exchange flows are controlled. It also governs how loans are registered, reported, repaid, or converted into capital. Understanding this framework up front helps companies avoid surprises later, especially when banks, auditors, or regulators start asking questions. In Vietnam, foreign borrowing does not fall under just one law or one authority. Several legal regimes typically apply at the same time. Investment and enterprise regulations govern how foreign invested companies operate, how capital is structured, and how ownership is recorded. At the same time, foreign exchange and banking regulations oversee cross-border borrowing, repayments, interest payments, and currency flows. As a result, companies borrowing from abroad often need to navigate both investment licensing requirements and foreign exchange controls. This dual-track structure is one of the key reasons foreign borrowing can feel complex, and why a clear legal overview is essential. Although the framework may seem broad, several themes come up repeatedly. Authorities will always look at who is borrowing and who is lending, including where the lender is based and what relationship they have with your company. They will examine the loan term and repayment structure, particularly whether the loan is short-term or long-term, and whether it crosses the 12-month threshold. Registration and reporting obligations are another central theme. Some loans must be registered, others reported periodically, and missed filings can create compliance risks. Finally, how the money moves matters. Funds typically need to flow through designated accounts, and currency use must follow foreign exchange rules. Understanding these themes makes it easier to assess whether a particular loan fits within the rules, or whether adjustments are needed. You might wonder why all these legal details matter in practice. The answer is simple, because they directly affect how your financing works. Banks may refuse to process repayments or interest transfers if a loan hasn't been registered or reported correctly. During audits or tax inspections, authorities may question whether a loan should be treated as debt or capital, especially if documentation is unclear. And non-compliance can lead to fines, blocked transactions, or reputational risks for the business. In short, the financing may work today, but without alignment to the legal framework, it can become a problem tomorrow. Here's a quick self-assessment you can apply to your current situation. Where does the funding come from? An overseas lender or a local entity? What is the loan term, 12 months or less, or longer? Have funds moved through a designated foreign loan account, or a general operating account? Has the loan been registered or reported, and are filings up to date? And do you have clear documentation on the loan amount, interest, maturity, and repayment? If several of these points apply to your business, your borrowing is likely within the regulated framework, and professional guidance can help ensure everything is aligned. At LTS Law Firm, we've guided foreign invested companies through Vietnam's foreign borrowing framework for many years. We help clients map their existing loans against regulatory requirements, identify where registration, reporting, or restructuring is needed, liaise with banks and regulators, and build internal processes so future borrowing doesn't turn into a legal surprise. With the right partner, borrowing from overseas can be structured smoothly, rather than becoming a regulatory minefield. If your business is borrowing from a foreign entity, or planning to, now is the time to review how that borrowing fits within Vietnam's legal framework. Don't wait for a bank, auditor, or regulator to point out a gap. Contact LTS law firm to review your foreign borrowing, align it with local regulations, and move forward with confidence. Visit www.lts.com.vn or reach out to our legal team for a consultation. Borrowing from abroad is a powerful tool. Used with clarity, it supports growth. Used without understanding the framework, it invites risk.